community. What is the sentence that is required to make sure the community is protected? Sometimes that's getting the person treatment. Sometimes that is removing them from the community for a long time because the crime was so severe. So I think what you have to do is you have to look at the facts of the case and apply it to those factors.
Thank you. Mr. Sigalski.
The three main factors are seriousness of the offense, character of the offender, and need to protect the public. Wonderful ideas, but how do you apply that in a particular case? Or, more importantly, how over a judicial career do you make sense of all those, given all the different cases that come forward? Back when I started law school in 1988, the professor in criminal law got up there and said there are 5 goals of the criminal law. Prevention, make that person not do it again. Locking up is wonderful for that, by the way. But we can't lock up everybody who commits any type of crime, like the one joint, for example. Deterrence, meaning deterring other people who might be committing that crime. Some people say deterrence doesn't work. I think we've got a crowd full of people here who think that deterrence does work because you're not out committing crimes, because you're moral, hopefully, ethical, plus you don't want to get in trouble. That is deterrence. The next one, we call it retribution, which is kind of a balancing of the law. If you follow the law, you expect other people to get punished who don't follow the law. That's retribution. That also is where victims' rights come in, to basically make that victim feel better because the person who victimized them is getting punished. Rehabilitation, certainly that's a big part of it. We talked about the drug court. That's a big thing as well. And the final thing really is what's called recidivism. Yet again, is this a repeat offender? Has this person been in court before? And I think that is a huge thing. Eric and I talk about cases all the time. Hey Ralph, I got this case. Hey Eric, I got this case. What's the record like? That's one of the first things we talk about. And believe me, that is one of the things that judges will certainly look at. And it's legal to do that. You can look at that at sentencing. Thank you.
Thank you. Mr. Bielko.
Is it the same question again?
Yes.
Okay. Well, I guess I can give you another example. You know, we have, I mean, a lot of these deliveries, you know, drug deliveries, I mean, the felony classification is higher depending on the substance and depending on the amount. You know, but I see people, you know, you have junkies selling to junkies, you know, who, I mean, that's not like the people who are sending to prison for a long period of time as though they're the people who are, you know, creating the drug problem, bringing big quantities in. You know, that's the minority of these defendants, right? You know, most of these people are just people with a drug problem trying to get a little money for their own, selling to people who also have a drug problem who are going to get their drugs from somebody else so they don't get it from this guy. You know, so you send these people to prison and you get to act tough and act like you got a problem off the street. Well, you know, I guess the drug problem in Manitowoc is solved, right? You know, it's been working great. You know, you have to have some sense of, well, wait a second, you know, this, you know, you can't treat the little guy like the big guy. You know, that's very, it's just counterproductive, you know. And again, another example, I mean, I've seen a guy who, you know, stabs, you know, violently, almost kills his girlfriend, you know, get less prison time than somebody who, you know, sells a little bit of, you know, whatever. I mean, any kind of controlled substance. I mean, this, you know, it's just out of whack. Things are out of whack, and we need to tackle that head on.
Thank you. Nancy?
You got a pretty thorough lesson in criminal law from my colleagues up here. Those are the factors we are directed to consider at sentencing. I think that everything everybody has said are appropriate factors for us to take a look at, but I think it's also important that we look at what else is going on. What else is going on in the community? Similarly situated defendants, what are they getting for this type of offense? It's important to try to maintain some proportionality, as I think Mr. Vilko alluded to. But at its most basic, the factors that a judge has to consider at criminal sentencing. What are the facts as proven? What does the law say? Apply the facts to the law. What does the community demand? What does the community require to be safe? And what else is going on in the courts around you?
Do you see a need for the law which puts 17-year-olds in the adult system for crimes to be changed to 18? Why or why not?
I think I'm first this time, right? Absolutely, yes, it needs to be changed. I don't understand where it came from in the first place. I've been an attorney for close to 15 years, and it's been 17 since I started practicing. It doesn't make any sense to me, right? If you look at the science of the brain development of juveniles, it's even past the age of 18 that these individuals have a brain that is fully developed to the state where they can make rational and appropriate decisions. And you do not make adult decisions at the age of 17. Our United States Supreme Court has recognized this fact and told states that they can't have the death penalty for juveniles because juvenile brain development, juvenile behavior is different from adult behavior. Our Supreme Court has said that states can't have mandatory life sentences for juvenile offenders because, again, the same reasoning. They recognize juvenile offenders are different from adult offenders. There is no reason to make it 17 that makes any sense that I can think of. It should definitely be changed at least to 18. And I don't know that you could go above that because you're an adult for everything else. But it certainly should not be 17.
Thank you. Mr. Skelski.
There is a provision in the law which allows for what's called a reverse waiver, where a young person under 18 can be waived back into juvenile court. The Slender Man case, I believe there was some of that going on with that. I didn't really follow that case very carefully, but there is that procedure. It is very rarely done. It is actually quite difficult for a young adult offender to end up back in juvenile court. I remember when this happened as well. Maybe I'm the oldest. Sorry, Pat, I'm one of the people here. And I remember when it turned into... Yeah, you look much younger than I do. So, but what it basically was that we had people 17 years and 11 months old committing horrendous murders who were getting lots and lots of younger people yet addicted to drugs, and people were fed up with it. So this was one of the responses. Is it a wise response? Isn't it? To be quite honest, that's not really the job of a judge. A 17-year-old charged with certain crimes under the statutes is in adult court. If a motion is filed for reverse waiver, you take a look at the criteria and the judge makes that decision accordingly. It is up to the legislature. Talk to your senators and congress people and your assembly people and those types of people to decide whether or not it should stay there or not. I remember what caused this to be put into place. If it changes, as the judge, you follow the law. Thanks.
Thank you. Mr. Malcolm?
I would agree with Mr. Pangburn for the reasons that he stated about juvenile brain development. And that's why we have expungement for people up to age 25, and perhaps that should be expanded too. And I think expungement is a great tool for judges to be able to try to keep young people from having debilitating criminal records that hold them back from getting jobs, getting into school, getting apartments for the rest of their lives. And one of the problems with the age of, I guess, adult criminality being 17 is we have people who don't have, I guess they could be 18 and have one more year of brain development, a little bit better judgment, committing crimes. They do something and it sticks with them their entire life. Should that person be not able to get a job or not able to hunt, something like that at the age of 40 because of something that they did when they were 17? I mean, I guess it depends in part on what they did and what they've done since. But when you are already sticking people with something that is permanent at that age, that's very hard to reverse. And 17-year-olds need more protection than they currently have under the law. But again, this is something where we have to use what we have. This is the law. You can't change the law as the judge. So when expungement is appropriate, that's something that you need to very seriously consider with a 17-year-old.
Thank you. Ms. Deeds.
I think it bears looking at and considering based on what we now know about brain development that we didn't know in the past. But I don't think it's quite as black and white as we may be tempted to make it. Prosecutors have a great deal of charging authority before a case ever gets to the circuit court, to the judge. And our prosecutors, we have to trust that they are looking at the factors, including age, when making a charging decision. There are also mechanisms to waive a juvenile into adult court for serious offenses. Just as there are mechanisms to waive juveniles back down to juvenile court when charged with very serious offenses. So I don't think that we could say yes across the board. I think it bears deep discussion and great scrutiny. I think the scientists need to weigh in, and I think the legislature has to make that call.
Thank you. Ms. Cochran.
It is the legislator's job And I made myself a note, John, you should consider running for that if you aren't successful in this one, because you've got the right ideas. I have had to set bail for a 17-year-old and tell him she, even in a couple of cases, that they couldn't go back to their home. And then the question is, what happens to this person? It's a violence case, it's where that's why we've put in that condition. So then, we've got this 17-year-old without somewhere to live. We have to get the CPS workers, the Children's Protection Services, over to help this person find somewhere to live, because the adult criminal system has put in this provision. Likewise, I have the 15-year-old delinquently charged child who is being placed in secure detention for a crime that the 17-year-old would be released for. There are some definite problems. I don't know if simply changing the age solves any of those, but there are some serious inconsistencies. There is some legislation being considered. Hopefully we see something. And the diversion program I referenced earlier is being used in part to help those 17-year-olds. And I hope more can take advantage of that.
Thank you. In some jurisdictions, offenders who have not paid their fines go to jail. Please comment on this.
Yes. I know that there's been some frustration in this very court when Dan Glazer was a municipal judge. I was renting from him back then, around the year 2000, 2001, and it was very upsetting that there really was no mechanism to put the person in jail. I got to admit, ever since Eric became municipal judge up in Two Rivers, I don't do a heck of a lot of municipal court work, but nevertheless, there are sanctions out there should a person not pay certain fines. In my opinion, not paying a relatively small fine shouldn't really hamper you too much. I think that there are good collection agencies out there. We have one of the best in the country, by the way, on the west side of town, AmeriCollect. They can try to collect fines. By putting them in jail, though, I've seen horrible things occur. People getting put in jail for not paying a fine. I've heard about this a few days before their wedding. Somebody who's diabetic, not being able to get insulin, that type of thing is a horrible reaction when you didn't pay a speeding ticket for $68 back in 2003. I stood behind somebody in an airport who missed their flight, their whole family did, because there was a parking ticket or something out there that wasn't paid. I think there are better ways to do that. Collection agencies are amazingly good at collecting fines, and I think that they should be referred to when it comes to that. Now, if you're looking at somebody with a $50,000 fine of some kind, like in a big federal case, okay, maybe that's a little different, but we don't deal with that here in the Manitowoc County Circuit Court system.
Thank you. Mr. Bilko.
Glad to hear Mr. Skigelski say that. Sorry I'm having a hard time pronouncing your last name today, but
Okay, Mr. Blanca.
but no, I agree, and I don't think we should have debtors' prisons. I don't think people should be going to jail because of poverty. That's not right. I think in the instances that he states, big fines, big offenders, yeah, that where somebody could probably be paying it but just doesn't want to. That's where people should possibly be going to jail. There's also child support that people go to jail for, and that's that can be a complicated situation. A lot of people kind of get down on their luck and get behind in their payments, and then they end up in jail after some numerous times in court oftentimes, but sometimes they end up in jail kind of after they get a new job and they have some old liens out there. Some people really just don't want to pay out of spite, and you're looking at contempt at that point, and I think you have to be able to distinguish those two types of cases when you're looking at putting somebody in jail for that kind of thing.
Thank you. Ms. Dean.
This is another area that I don't think is quite so black and white as it may be easy to look at. I think there's a difference between a criminal fine, where it is sometimes an alternative to loss of liberty, but you choose not to pay that fine when you've opted for that. Perhaps at that point, the loss of liberty is an appropriate way to actually enforce the punishment. No other criminal sentence has that kind of way out. You just don't go to jail. You're going to end up in jail if that is your sentence. But if you just don't pay your fine, then there really is no punishment, and it sort of undermines the entire system. I think it's a little more problematic when we're talking about incarceration for not paying a civil forfeiture, a traffic ticket, that you would not go to jail for violation of that offense or for committing that offense under any circumstances. But if you don't pay, you can end up in jail. But the flip side of that is what alternatives do jurisdictions have to collect the money that is necessary in a lot of cases to keep the system running and to keep the government functioning. So I don't have a clean answer, yes or no, but I think that there are some areas in which it is problematic.
Thank you.
Ms. Papa?
I agree, it's interesting that we're in this room and that this room gets used as court. There's a difference right now, as I understand it at least, that there are some very policy decisions that have been made regarding collection of fines from Manitowoc County. And we very recently decided that we were going to rely on the collection system as opposed to jail for failure to pay fines. Whether we've made the distinction Ms. Dietz mentioned or not regarding the criminal fine in lieu of sentence, that's a good question. We should make sure we're looking at that at least. A lot of times it's not getting to the judges anymore, and I would like to see the judges involved a little more in some of these decisions. I agree that putting a person in jail when they're honestly unable to pay does not make sense. And we all know that there are many jobs that don't pay enough to keep the person in a reasonable state of living. If they can't pay their rent, how are they supposed to pay their fine on the job they have? And then we put them in jail and they lose the job. It's a bad cycle. So we need to be using our discretion, using our common sense, and looking at everything.
Thank you. Mr. Bainford?
I deal with this issue all the time as a municipal judge for TERS and Mishicot, and there's a couple things you need to understand, at least at the municipal level. You cannot go to jail for not paying a traffic citation, right? You can't go to jail for speeding. The law does not allow that, so that's not happening to people. The remedy for non-payment at the municipal level of a traffic violation is a 1-year driver's license suspension. That is the only remedy. The remedy for non-payment of non-traffic offenses at the municipal level is a commitment. And you can commit a person for 1 day for every $50 that is not paid. So that is an option. But you cannot enforce the penalty if the person is in poverty. The law says you cannot. So if you come to my court and you say, I can't afford to pay my speeding ticket, there are criteria for determining if a person is in poverty. And if they are, you have to work something else out. You can let them work it off with community service. You can suspend the fine entirely. You can give them a much longer repayment plan. I've had people on plans as low as $10 a month. And as long as they make the payment, nothing happens to them. It's the same thing in circuit court under the Blessinger case. If you have if you haven't paid your court costs and they're going to pick you up on a commitment for that, you have the right to go in front of the judge and tell him it's because of poverty. And if it is, they have to let you out.
Thank you. I think we'll have one last question, and then we'll go into closing statement. We've been at this for more than an hour, and I firmly believe that the mind can only absorb what the so, what do you believe a judge can do to best address safety issues in the community? Mr. Segal.
I think I just did the last one first.
No, actually, I'm sorry, John.
Oh, you did. Okay. Well,
You were last, yeah.
Yep, we'll get it down.
With the last one?
5 people is more than I usually have to worry about.
Someone could drop out.
Somebody will cut the floor up too late.
Order.
Here.
I think you have to just, I mean, the main thing is,
Start over with say the
Question again.
Safety.
what can a judge do to improve
to
public
best
safety?
address safety issues
Correct.
in the community.
Well, people who are out and going to hurt somebody, you need to remove them from the community. That's important. You have to think about the sentence that you're going to give, though, when it's a especially a non-violent offense, you can't just kind of give a knee-jerk response and simply decide to give a certain sentence because it looks tough or it's asked for. You have to think carefully about what is going to happen to, let's say, that person's family, that person's employer, before you give that sentence. That is very important for safety, and that's something that people forget. I mean, of course, they have to consider, well, does this person need some punishment to convince them to stop? Do other people need to see this person to convince, punished to convince them to stop? Those are important safety considerations too, and I think every judge is looking at that. But sometimes we forget some of the ripple effects, and I think just being able to balance those and weigh those out, not see things as black and white cases, is very important for public safety. And also just kind of, doing a little bit of research on what's working, what's not. I got to take my hat off to Pat for everything she does with CJCC. She's as involved as anybody in learning about things and very up on that, and I do my best.
Thank you. Ms. Deeds.
I think thoughtful, conscientious sentencing is an important step for ensuring community safety, but I think there's more to it. I think leading by example is important. I think a judge needs to be a community leader as well as a courtroom leader. I think that the courthouse needs to be a place that leads the community in how we're going to set standards, how the community wants the world to look in our world, how they want crimes to be addressed, what we want as a community, Manitowoc County to look like. I think judges need to be aware of that, and they need to lead. They need to be very careful about every step they make in the courtroom and outside the courtroom to make sure that they are carrying through those community morals and being very thoughtful in what they do in the courtroom and out.
Thank you. Ms. Coppa.
Reflecting on what role the judge actually has. And I like the reference to the judge being a community leader. Recently, the rules regarding judicial conduct have kept our judges from being part of the community. But I know there's some wiggle room there. There are some things that are allowed. And I think we haven't been doing that. I'd like to see the judges do that to the extent possible, to do the community education that can be done. And by educating the populace that would come to such things, you actually do improve community safety. You have an awareness and an understanding. What we've talked about tonight with the diversion programs, we've educated a whole room of people that these exist. If people don't know what is being offered them, they aren't going to accept it. So I think even in this capacity, we've done something to improve community safety.
Thank you. Mr. Painter.
We've touched on it a bit here tonight. Judges are limited, of course, by the resources that we are provided. And you need to have the ability as a judge to examine every case, determine what risk that person presents to our community, and fashion a sentence that's going to reduce that risk as much as possible. But that's only part of it. I think judges can be advocates for the very system that we're part of. We are sitting up here saying the legislature is not giving us the resources we need. Well, then judges should be paying attention to the bills that are pending before our legislature. Those bills have public hearings. We should be going down there to Madison and participating in those hearings. We should be telling, as a judge, you have a unique perspective and you know what's needed. So we should be there telling our legislators what we want, what we need to make our communities safe. That's what judges can do to improve our safety.
Thank you. Mr. Sigelski.
I think the real high water, the tide that has come in regard to safety is this. The cell phone. You pull it out, you record the person acting violent. I got to tell you, with injunction hearings, when there's domestic violence, which by the way spawns then later violence later on, it's very rare not to have video of that or some text messages that express a desire to do violence to somebody. That is changing the way the world is working right now. Because the cell phone is there, it's handy, we can take pictures, we can take video. If somebody starts erupting right now, the cell phones are out, and you don't have a trial. The case basically gets resolved. What can judges do in that regard? Well, obviously, they can admit and hopefully get the technology in the courtroom to see that in court quite easily. I mean, as a lawyer, back before cell phones came along, some guy would come in, he's accused of domestic violence, he denies anything, blah, blah, blah. You go to a trial, who's more believable? That's the way it occurs. Now you pull this out, okay, case over, we're done. That's the way it kind of works. So having that in the courtroom, that tech capability in the courtroom is very, very important. And I will admit, of the 5 people up here, I am the most tech illiterate person up here, okay? Mike Lambert's in the back of the courtroom. We had a 2.5-day divorce trial about 13 years ago. If we had these, Mike, we would have resolved it. You and I both know that. And I think that's the way the courtrooms have to work to enhance the safety. Tech is the way to do it. Squad cameras, body cams. Thank you.
Thank you.
So we start on this end this time?
No, I think we're going to now start with the closing statements. 1.5 minutes each, and we'll start with the themes.
I don't really want this to be a closing though, because I'm really kind of excited that we have a time to mingle afterwards and have a one-on-one discussion and conversation. So I don't really want to close. I just want to add a little bit more. We're all here asking you to give us the honor of your votes on February 20th for the primary, and then for the 2 that advance on April 3rd at the general election. I think what we're doing here tonight is vitally important. This kind of engaged discussion over these matters, the issues that matter very, very much to all of us. This is terrific, and I think we're accomplishing something great by doing this. I have 4,000 circuit court cases under my belt. That's a drop in the bucket because every case is different. We all bring something really interesting to the table. We all have different perspectives, and I hope that whoever is elected here, I hope that we can all continue to work together. As you heard tonight, we have a lot that we agree on and a lot we don't agree on. And if we can all work together, and everyone in this room, collectively, we can make a tremendous difference in this community. So I hope we'll have a good judge to lead the way and a whole army of people to help carry it all out. Thank you.
Thank you. Ms. Kappa.
Well, again, I'm going to just say we have a lot of experience at this table. Mine is more judicial. Yes, we have another judge, and he actually gets to be called judge, so that's great. But you have to decide what it is you want to see in your next judge, and which individual can do that. Everyone wants something different, and maybe in some ways it's a good thing that most voters don't have to come to court, but you still want to know what the judge is, and you want that judge to represent your values, your perspectives, and to be a leader for the community. And I hope you vote for me in that respect. Thank you.
Thank you. Mr. Banker?
If you talk to other lawyers and judges, they will tell you that what you want in a judge, and when you look at the experience level and where that person is at in his or her career, is someone who's been practicing law probably about 15, 16 years, and is prepared to go forward as a judge for 15, 20, 25 years. Right? These people are elected to 6-year terms. I've been a lawyer for about 14.5 years, and I'm prepared to serve at least 4 6-year terms. That's 24 years where you will have the same person, the consistency, the experience, the knowledge base that is required to handle these cases. If you talk to judges, they'll tell you that first term, or at least a large part of that first term, is required simply to get up to speed on what's going on. Right? And then you can spend 2 or 3 or 4 more terms taking that knowledge and that experience and moving forward and doing great things for our community. If you vote for me, it is my intent. You don't want career politicians, but you do want career judges. And if you vote for me, it is my intent to be in this position for 20-some years. I have been a member of this community since I was 3 years old. My wife has been a member of this community since she was born. We are not going anywhere. Thank you.
Thank you. Mr. Sigelski.
Eric, for the second time, I have to disagree with you a bit. Judge Willis, I believe, spent 14 years on the bench, and he was an incredible judge. And he did not get to the point where he was burnt out. I have seen judges, it's at about the 2.5-year terms, about 15 years in. There's a little bit of burnout that occurs, a little bit of anger maybe, I don't know. Things happen. I've been around long enough to see that. Judge Willis at 14 years was an exceptional judge, and he retired. Judge Fox, who just stepped down last year, 12 years as a judge after about probably about 30 years of experience as a lawyer. A great judge, very, very good judges. I think sometimes what happens is if you don't have a tremendous amount of experience as a new judge, especially in all three big areas, civil court, criminal court, and family court, you get somebody who has to work very hard on that bench to get used to those areas. You know, somebody who's very big into family law and civil law, well, all of a sudden they're getting 70% of their caseload is criminal law. And the sentences are kind of all over the place for a while, then they finally settle in after a few years. But the first person who's there in a criminal case, and the victim of that person deserves a judge who really knows what is going on from the first day they step on the bench. I am 52 years old. I plan, if I am elected, and if the voters see fit, to spend 2 terms on the bench, 12 years. I will take charge that first day in the courtroom, listen carefully, be patient, and be ready to go that very first day. Thank you.
Thank you. Mr. Bill?
Thank you. I think what I bring to the bench is a lot of transparency. You will understand my reasoning process. I think I've been pretty clear about that today, and I would continue to do that on the bench. I don't think that a judge's philosophy should be a secret. I think that that's something that is part of why a community should select a judge. I'll bring a very independent perspective to the bench. You know, again, I'm the youngest one here, but 7.5 years of practice. I've learned a few things, and I'm very rooted in the community. This is where I grew up. I want to see Manitowoc develop. I love this community. I'm dedicated to it, and I'll put all my energy into it.
Thank you. I would like to thank all of the candidates tonight for the civil discourse that we have heard tonight. I wish that